Hello everyone and welcome to my channel. So in today's video I'm going to be reviewing the ICAN business law textbook. This business law is a paper under the foundation level, so I'm going to be starting with the very first topic here, which is the Nigerian legal system. And in this topic I'll just quickly highlight this content we are seeing here, which has to do with law and its sources, the sources of Nigerian law. And we know that there are different sources of Nigerian law. We have the received English law, which under it we have the common law, doctrine of equity, statute of general application. And aside from the received English law, we also have the Nigerian legislature and Nigerian legislation, which has to do with the constitution, Nigerian constitution itself. And also, far from it, we still have customary law, we have the judicial precedents, we still have the international law. So and all these are sources of law. After when I've highlighted a few about that, I'm going to be moving straight up to the legislative process. And knowing fully well that the legislative process will be looking at also the distinctions between civil law and criminal law, and other things follow. So in a nutshell, I'm going to be defining law. Law, according to John Salmon, is a body of principles recognized and applied by the state in the administration of justice. So more or less, law it is that body of principle that help in social control. We could find out that law differentiates itself from ethics. Ethics is a moral persuasion in a given profession as to, okay, this in, let's say for instance, we have ICAN, for example, and there are a set of rules that the professionals have to follow in order to do things rightly. In that same manner, it's not the same with law. Law is a body of principles recognized by a state, a country. It's not a profession, it's not an association matter. It has to do with a country, a state. So the body of principles that is recognized by that state and country in the administration of justice is what we refer to as law. And there are different sources, like as mentioned earlier. We have the first one, which is the received English law. Now, like the word say, received English law. These are laws that were passed down from our colonial masters, which is the Britain to Nigeria. And first of which is the common law. The common law has to do with the law that were, that were common to England as a whole, that were uniform to England as a whole, as opposed to local customs peculiar to an area. So in common law, we're not just looking at laws that affect a particular area, or laws that are applicable to, let's say, Nigeria. Now we are not just looking at law that is applicable to just Imo State, or laws that are applicable to just Lagos State. We're looking at laws that are applicable to Nigeria as a whole. So in that same manner, we can define common law as laws that are uniform in the whole of England. Remember, this law are England law, so we received it as the colonies. We received those laws from our colonial master. So the next source of law is the doctrine of equity, and under the doctrine of equity, we are made to understand that it was actually created, it was passed down just so it could supplement the common law and reduce the harsh effect of the common law, because we find out that the common law is rigid, and also one of the remedy in common law, let's say for instance you're seeking remedy in common law, you only what is available for you is damages, you get. Whereas if someone trespass on your land, for instance, now you don't expect the person to just pay you damages. You actually want the court to give an order to stop the person from trespassing on your land, and that is called injunction, an order to refrain someone from doing something or not. So equity came to supplement the, the inconsistencies of the common law. So under equity, we have different remedies we have the specific performance, we have the injunction, we have rescission, we have rectification. So you could find this in your textbook. You're going to read more about it. Yeah, like I said, I'm just giving highlights to it. So we have the maxims of equity, and there are 12 maxims of equity right here. Yeah, one thing I love about this maxim is that it has its peculiar meaning. Yeah, and if you actually deal with land cases, or if you've actually been involved in land cases, you'll find out that most of these maxims come true. You get one of which is this: delay defeats equity, or equity aids the vigilant and not the indolent. You find out that there are times when things will happen, and then you, like someone is doing something against you, but instead of you to just report the case or take up the matter, you relax, you sit back and relax while that thing is going up. In the law of equity, when you delay in prosecuting a case, well, at the end of the day, you might not win that case because of that delay. So it's more or less like say delay defeats equity. So even if you are right, so far you delayed in taking up the matter, you might not win the case. So it's also look at the fact that if you actually come to equity, you must go with a remedy. You is not Equity will not suffer a wrong to be without remedy. That's number one there. Yeah, and if you're actually seeking equity, you must also do equity. You get so, and you must come with a clean hands when you actually come to equity. And now we look at other source of law, the statute of general application. Now these statutes are laws that were in force in England before or on January 1900, 1st of January 1900. Now, and they became part of Nigerian law by virtue of the adaptation laws. So these laws, we're talking about the Sales of Goods Act in 1893. We also have the Partnership Act in 1890. These are the acts that are in force in those times, and you find out that even in our current Nigerian legislation, we still find those acts speaking for us here in Nigeria. Also, we have the Constitution of Federal Republic of Nigeria, and it has its characteristics just as we've seen here. Yeah, and we also have the customary law. Now, one thing that ICAN has always pointed out in its question that I've noticed is the part of this validity of customary laws. Yeah, we found out that they're always asking questions on, okay, fine, how do we test in cases of customary matters? How do we check the validity of customary laws, since customary laws are largely unwritten? Yeah, and we kind of will I say we beckon on the knowledge of those persons that are elderly to give us the true law that is governing that land. So more or less, we tend to check the validity of customary law to ensure that it is not repugnant, that is, it is not barbaric, and also it is not contrary to an existing law, which is incompatibility test. This incompatibility test talks about its contrariness. It must not be contrary to the existing law. Let's take, for instance, we have a law that has abolished the killing of twins. You get, that's maybe that law have been invoked, and then later on you now find out that some elders come to now say, no, we will kill twins in this land, whereas there's already a law speaking against it. So if anybody find himself in that kind of matter, he could actually seek redress in court, and he will win the case, because those elders, in as much as they uphold the custom of that land, yeah, they're actually saying something that is against the existing law. So that is incompatibility. Another one is the test of public policy test. Yeah, publicities are where they'll bring people to, like the elderly, like I mentioned earlier, to come and testify, give direct oral evidence or documentary evidence, yeah, as to the the law and custom of that land. So we also have the judicial precedent, and on that judicial precedents are more or less like the decisions of the courts in time past. So we are talking about